Stop whatever you're doing. A massive new U.S. immigration law could slash green card wait times, fast-track workers and dreamers, and at the same time quietly put thousands of green cards at risk. Watch till the end to see if you're on the winning or losing side. If you have a green card, you're waiting for one, or you're just starting your U.S. immigration journey, what I'm about to explain could completely change how you think about your future in America. Some people would benefit a lot from changes like these. Others would face new risks they can't afford to ignore. You're watching U.S. Citizenship and Visa. This channel uses an avatar and clear, simple language to walk you through real U.S. immigration concepts, news, and reform ideas, so you can understand what's happening and plan your next move with confidence. In this video, I'm going to explain a major immigration reform scenario step by step. Think of it like this. If a big new U.S. immigration law is passed with the kinds of ideas already being talked about in Washington, here's how it would affect green card holders, workers, students, healthcare professionals, dreamers, entrepreneurs, and investors. Very important before we move on, always check what has actually passed on official government websites like USCIS.gov and travel.state.gov before you act. This video is for education. It is not personal legal advice, and it is not a substitute for reading real laws and policy updates. With that clear, let's get into it. Imagine a new law that finally takes the employment-based green card backlog seriously. For years, people in EB1, EB2, and EB3, especially from India and China, have watched their priority dates crawl forward. Sometimes they even move backward. People stay on H-1B or other work visas for a decade or more. Their kids age out. Their lives are on pause. Now imagine that this new law says, once your employment-based green card case is actually ready to be decided and a visa number is available, USCIS must process it within 180 days. 6 months, not 3 years, not whenever we get to it. 6 months. To make that possible, the law gives USCIS more money. They hire more officers. They open more offices. They digitize more of the system so they aren't pushing around huge piles of paper files. They are required to hit that 180-day target for most employment-based green card cases when the priority date is current and the application is complete. On top of that, imagine that there is a real premium processing option for adjustment of status itself. Right now, some petitions can be premium processed, usually by the employer paying a big fee, but your I-485 green card application does not have a broad premium option. Under a reform like this, for an extra fee, once your date is current and your file is complete, you could request premium processing of your green card application. That could mean a decision in, say, 30 to 45 days. It would not guarantee approval, of course. USCIS would still check eligibility, security, and any grounds of inadmissibility, but it would force them to move and give you an answer. If you're on H-1B, L-1, or another work status, and your I-140 is approved but your future feels stuck, this kind of rule would be huge. It would mean your life is not permanently locked into maybe next year mode. It would also help your spouse and children who are stuck in dependent status and can't fully plan their own futures. Now, let's talk about something that would make many existing green card holders pay a lot more attention: stricter rules on travel and residence. Right now, the rules about how long you can stay outside the U.S. are a little fuzzy for many people. You might have heard things like, come back at least once a year, or don't stay out more than 6 months. There are already laws about abandonment of residence, but a lot of people treat them loosely. Under a stricter law, those rough guidelines could become clear triggers. For example, imagine the law says, if you spend more than 6 consecutive months outside the U.S. without a re-entry permit, your case gets automatically flagged for review as a possible abandonment of residence. If you stay outside the U.S. more than 1 year without a re-entry permit, you are presumed to have abandoned your green card unless you can strongly prove the opposite. What would strongly prove mean? Things like owning and maintaining a home in the U.S., having immediate family members living in the U.S., keeping a full-time job in the U.S. or a clear ongoing work relationship here, and filing U.S. tax returns as a resident. In other words, under a law like this, you could not just live abroad for years, visit the U.S. briefly, and expect your green card to be untouchable. The government would be watching more closely to see who is truly a U.S. resident and who is not. Now add one more idea: a simple, yearly online confirmation of residence form for green card holders. Once a year, every green card holder logs into a secure USCIS or DHS portal. They confirm their current U.S. address. They confirm they still live primarily in the U.S. It takes 5 minutes, but if you ignore it for too long, your case could be flagged for review. If you live in the U.S., work here, pay taxes, send your kids to school here, and you do not spend long stretches outside the country, you probably have little to fear from a rule like that. It would mainly hit people who are using the green card as a travel convenience or as a backup plan, while really living somewhere else. But it would also mean you need to be more careful. You'd need to plan long trips abroad more carefully. Apply for re-entry permits when you know you need to stay outside for many months. Keep clear records of your travel, and watch your email and mail for any online confirmation reminders. The message from a rule like this would be: a green card is for people who really live in the United States, not for people who just want easier entry once in a while. Now let's switch to an area where this kind of law could be very generous: healthcare workers. The U.S. is facing a serious shortage of nurses, doctors, therapists, medical technicians, and long-term caregivers. Hospitals and clinics struggle to keep enough staff. Nursing homes are often understaffed. Families have trouble finding home health aides. A reform law could create a clear, fast-track green card path just for healthcare workers. In that kind of system, if you are a foreign nurse, doctor, medical assistant, therapist, or similar professional who has been working in the U.S. on a temporary work visa, you could apply for a green card without going through the full labor certification (PERM) process, as long as you meet licensing and job requirements. You could use a special healthcare category with its own annual quota, for example, an extra 25,000 green cards per year, separate from normal employment-based caps. USCIS could be ordered to handle these cases faster because the U.S. has officially decided that healthcare professionals are a critical shortage group. Employers in hospitals, nursing homes, and clinics could sponsor you more easily and get you to permanent residence in a shorter time. There would likely also be protections to prevent abuse. For example, employers would not be able to threaten to cancel your sponsorship easily to control you. Wage requirements would match U.S. standards for your role and location. You might have some flexibility to change employers without starting the process from zero. If you are a nurse from the Philippines, a doctor from Pakistan, a caregiver from Kenya, a physical therapist from Brazil, or any other healthcare professional already working legally in the U.S., this kind of pathway would be your golden chance. Under a law like this, your next steps would be to collect your licenses, diplomas, and experience letters. Get organized documentation from your employer. Talk to an immigration attorney or a trusted legal aid organization, and be ready to file as soon as the rules are live. Now we have to talk about public charge. Many people are afraid of this term, often based on half-true or outdated information. The basic idea of the public charge rule is that the government can deny a green card if they believe someone will depend mainly on certain government benefits in the long run. A tougher version of the public charge rule could say something like this: if you have used certain listed public benefits for more than 12 months in total over a 3-year period, that fact will weigh strongly against you in a green card or adjustment case. That doesn't mean automatic denial, but it does mean more questions and stricter review. The types of benefits that count are usually very specific, often things like long-term cash assistance, some forms of housing benefits, or certain types of Medicaid support, especially if they are your main income. Short-term emergency help is often treated differently. Under a stricter public charge rule, USCIS would look at your overall financial picture. Are you employed, even part-time? Do you have a history of working when you were allowed to work? Do you have savings or assets? Do you file tax returns? Do you have a joint sponsor or relative clearly able to help if needed? If you fell on hard times briefly, for example, because of a medical emergency or a layoff, and used some benefits for a short period, that might not destroy your case. The details would matter. But long-term dependence on cash assistance or similar programs under a stricter rule would be a bigger problem. If you are planning to apply for a green card under a tougher public charge environment, your best strategy is to focus on stability where you can. Get and keep legal employment if you are allowed to work. Pay taxes and keep records. Build some savings, even modest. Keep copies of pay stubs, bank statements, and tax returns. This kind of rule would not exist to punish every struggling family. It would exist to push the system to favor people who show that, over time, they can mostly support themselves. Now let's look at a part of reform that, for many people, would be the most emotional, a direct path for Dreamers and DACA recipients. For more than a decade, hundreds of thousands of people who were brought to the U.S. as children have lived with temporary programs, renewals, court fights, and constant uncertainty. They grew up here. Many barely remember any other country, but they have never had a clean, permanent path to a green card written directly into law. A strong reform law could finally fix that. It could say, if you were brought to the U.S. as a child, have lived here continuously for a certain number of years, have no serious criminal record, and meet education or service requirements, you can apply directly for permanent residence. No more 2-year renewals. No more, maybe it will end next year. The law could also allow, after a period of time, for those new permanent residents to sponsor certain family members, like spouses and children, under clear rules. Processing for Dreamer cases might be given a target, like a 1-year average, with additional support for fee waivers or reduced fees for those who truly cannot afford them. For a Dreamer or DACA recipient, this would mean time to gather proof of your residence since childhood, time to gather school records, diplomas, and any military or community service evidence, and time to correct minor issues with the help of a lawyer before you file. It would be the chance to stop living as temporary and finally become what your life has already been, the life of someone who truly belongs in the United States. Now, let's talk about another big group: entrepreneurs and investors. For years, if you started a business in the U.S., hired American workers, raised money, and created real value, the immigration system still often had no clean category for you. Many founders bent themselves into H-1B or O-1 shapes that did not quite match their actual roles. A good reform could change that with a clear startup green card category and tweaked EB-5 investor rules. A startup green card pathway might say, if you founded a U.S. startup, raised at least a certain amount, say $250,000, from qualified U.S. investors and created at least 5 full-time jobs for U.S. workers, you can apply for a green card based on that business. You are not just an employee of someone else. Your company itself is the basis for your status. Meanwhile, an improved EB-5 program might lower investment thresholds in certain rural or high unemployment areas to around $500,000 from higher amounts, tighten project oversight and anti-fraud measures so investors and their families are safer from scams, and speed up processing so families are not trapped in EB-5 limbo for endless years. For you as a founder or investor, that would mean, if you build real jobs or invest serious money into qualifying projects, you get a predictable path to permanent residence. Of course, you would need strong documentation, company formation documents, tax filings, payroll records proving full-time U.S. jobs, investment agreements, and bank records. And you would need to avoid paper-only projects that exist mostly to sell green card promises without creating real economic activity. Finally, let's look at a change that would touch every single green card holder if it became law: mandatory biometric renewal and digital green cards. Under such a system, your green card would still have a 10-year expiration date on the card, as many do now, but the renewal process would always come with updated biometrics. That means you file your I-90 or successor form to renew your card. You receive a biometrics appointment at a USCIS application support center. You go in, provide fingerprints again, a new photo, and possibly an iris or facial scan. Then you leave, and later receive an updated card. The idea is to keep government databases refreshed, reduce identity theft, and keep track of who is who in a system with millions of records. In addition, there could be a digital version of the green card, a secure encrypted digital credential linked to your USCIS account or a government app. This could allow faster verification by employers or government agencies. If the physical card is lost, the digital record is still there. For you, the main responsibilities would be: do not ignore your card's expiration date, do not skip or blow off biometrics appointments, and reschedule quickly if you cannot attend. The upside is that your identity and status are better protected, and many processes, like employment verification, might become faster and more secure. So, stepping back, what does a reform package like this do overall? It makes the system much more welcoming and efficient for some, employment-based applicants stuck in backlogs, healthcare workers, dreamers, founders, and investors. At the same time, it makes the system stricter and more demanding for others. Green card holders who spend a lot of time outside the U.S., applicants who rely heavily and long-term on certain public benefits, and people who ignore renewal and reporting requirements. Your job in a world where a law like this exists is to understand exactly which parts apply to you, use the opportunities it gives you, and respect the limits and requirements it imposes. You've worked hard to get to where you are. You don't want to lose ground because of misunderstood travel rules, ignored forms, or guessed financial assumptions. You've been watching U.S. Citizenship and Visa. If you want clear, detailed explanations of U.S. immigration rules and reform ideas in simple English, make sure you subscribe and turn on notifications so you never miss an important update. Now I want to hear from you. Where are you watching from? Are you already a green card holder, or are you still waiting? Which part of a law like this would help you the most, and which part worries you? Drop your answers in the comments. I do read them, and they help guide what we cover in future videos on this channel. If this explanation helped you understand how a big immigration reform law could reshape green cards, work visas, healthcare immigration, DACA, startups, and more, please like this video and share it with someone who needs to hear it. Stay informed, stay compliant, and most of all, stay hopeful and prepared. This is U.S. Citizenship and Visa. Thank you for watching, and I'll see you in the next update. Stop whatever you're doing. A massive new U.S. immigration law could slash green card wait times, fast-track workers and dreamers, and at the same time quietly put thousands of green cards at risk. Watch till the end to see if you're on the winning or losing side.